This session is on best practices. Right? Just says best practices. So I am assuming that there is best practices to prepare for the judicial exams. All right. The first tip before I start, I should tell last year in the academy I had a senior colleague who is now working in Hassan who addressed you. I had a student of CMR last year. These tips were prepared by both of us together. So credits to him also for these tips. Okay, with your acknowledgements, the first tip I would give is an aspirant must develop self-confidence, determination, dedication, commitment, and skill for proper execution of the task of preparation. This preparation is not like the exam is being announced today. It is going to take place in about a month, and I'll start preparing from tomorrow. It is not like that. It is a continuous process. It starts from the first year of your law school. This is how it is going to be. You have to keep reading the newspapers daily. So it is a comprehensive task that happens, and it should be consistent. It is not like I have read something today, so 1 month ki chutti and then I'll resume after a month when exams are announced. It is not like that. It has to be a continuous process, and one should stay committed to the task. As in a fixed time daily. This time I'll study, this much I'll study. You have to have thorough knowledge of the procedural and substantive laws. That is the second tip. To have thorough knowledge of the procedural and substantive laws, you have to study a lot. Along with that, if you are attending an advocate's office, that is like icing on the cake. As I was mentioning to you, that practice comes very is of great benefit when you are appearing for the judicial exam, and even when you become a judge. So, having practical knowledge, experience always comes handy. Being updated with the recent case law judgments, decisions of the Honorable Apex Court and High Court of Karnataka is imperative. For those of you who are from the other states of your respective High Court. Recently we had a batch from Karnataka Judicial Academy of the Punjab Kerala visiting our academy for a knowledge exchange program. And we had officers there who have studied in Bangalore. So some of you may go back to your state, you may appear for judicial exams there also. So common thing is Supreme Court decisions, you have to be aware of the latest decisions. You have to be, there are questions in the exams based on those decisions. Also, along with that, you have to, your respective High Court, for those in Karnataka, judgments of the Karnataka High Court, you have to be updated. Certain landmark decisions are there, for example, on the page where the Sarfaraz Hussain recently Supreme Court has given a direction based on its earlier judgment in Rahul Shah's case that execution cases have to be disposed of within 6 months. All these landmark decisions, you have to keep a track of them, make notes of them, and keep them handy so that they will be of great benefit for your judicial exams. One should prepare a proper study plan with timetable so as to dedicate required time to study for each subject in the syllabus. Having prepared a timetable, one should stick to it meticulously. This avoids last-minute anxiety. So, have you watched that movie? What is 12th Fail? Yes. It is something like that. So that makes my job easy. So, prepare a timetable. Prepare not. It's not exactly something like Monday CPC, Tuesday CRPC, something. It's not something like that. Just have a time frame to which you should stick to and keep studying so that you are thorough with all the substantive and procedural laws, and the list of subjects already others have shared with you. It is always mentioned in the notification. barracks, latest barracks. The list of subjects have been given to you. If you want, I can repeat those subjects. They are available in the notification also. Those subjects, for example, Contract Act, Individual Instruments Act, Personal Property Act, specifically back, all these barracks, keep them with you. And whenever you have something in your mind, some thought about any provision, just open the barrack and read it. Okay? Even otherwise, even if you don't choose to be a judicial officer or a judge, even if you choose to be an advocate, one advice that I would like to give you from my limited experience is that reading barracks is very important. Study of law should start from reading barracks, not from any case law or any judgment or any commentary. So the first thing is reading the alphabet, then you start reading the words, then it is like that. Barracks first. Read the barracks, have your own understanding, then to have a better understanding, read commentaries, read case laws. As far as possible, keep yourself away from all kinds of unnecessary distractions, especially the social media. I saw two people wearing AirPods, crossing each other, one saying to the other, "Are you going to the coffee shop?" He saying, "No, dude, I am going to the coffee shop." It shouldn't be. Then, yeah, see, social media has distracted us so much. So, during the phase of your preparation, keep these distractions away. You must have seen during the morning program, I have been using my phone. I'm getting messages from office. I was delivering a lecture, I was collecting some material for one former honorable judge and sending it online. All those things I was doing. I was using it for a purpose. But when I open the phone, suddenly I don't go to SEC Online or Lido or anything. There is this tendency to go to the WhatsApp. Okay, so that social media is such a kind of thing, it will keep you distracted. So try as much as possible and avoid such distractions or any other kind of distractions. Not to blame social media alone, but there are other kinds of distractions to decide. इसके साथ जाऊँ या उसके साथ जाऊँ, कॉफी. At the time of studying and preparing for the exams, make your own notes so that it is easy to revise immediately before preliminary exam. This notes will also come handy at the time of preparing for the main exam. See, we may read guides. There are guides for judicial exams, many books, which are available in the market or bookshops. But nothing like your own notes. So when you are revising, your own notes are like your own babies. You know them better than other books. So make notes, make exhaustive notes and keep them ready. It will not only help you for these preliminary exams or interview, later also in life, by whatever profession you choose, judiciary or otherwise, they will always help you. But those notes have to be updated. Alright, we had a lecturer, not Subramanian sir. He was teaching us international law. He was student of Subramanian sir. And he won't read anything else for his classes except those notes made by him after hearing lectures by Subramanian sir. So he was refusing to update. But our always due respect for him, he was a wonderful teacher. But what I'm telling is, those notes that you make have to be updated from time to time so that they don't get irrelevant, don't become irrelevant. Regular practice leads to perfection, therefore practice regularly by solving question papers of exams from the previous year. Okay, almost I was mentioning to you that question papers are available on the website of the High Court of Karnataka. So all previous question papers have been uploaded, but those question papers may help you from say 30 to 40% or roughly 30% because most of the questions may not get repeated or maybe in a put in a different fashion. So those question papers help us in understanding the pattern in understanding how to go about these questions and answering them. But though question papers are very useful in preparation, but solely do not rely on these question papers. As the subjects such as the CPC, CRPC, Evidence Act and Constitutional are also required to be studied for the main examination, one is advised to study these subjects thoroughly by giving more importance. Alright, that is more of self-explanatory. Remember that preparation for examination is not complete without periodical revisions. Yeah, revisions are very important. As I told you, take your own notes, keep revising, keep updating your notes. Preliminary examinations consist of 100 multiple choice questions which have to be answered in 90 minutes. That means for each question you have less than 1 minute. Okay? Therefore, time management is important. One should keep in mind that there is no negative marking. So, as there is no negative marking, it is better to answer all the questions. Try to answer all the questions. If you come across a question that requires more time, at that particular time you are not able to decide which one is the right answer. Keep it aside for a while. Go ahead, then again come back. As I told you, preparation is a continuous process. You have to keep preparing every day, and it is not only about reading law books, it is also about reading the newspaper, the magazines. It is about reading the online journals. It is about all physical journals for this matter. About keeping yourself updated with the latest case law. Question papers I have already mentioned that they are available on the website. Now we will go to main examination part. So here in the main examinations, once you clear the preliminary examinations, you will be eligible to appear for the main examinations. Main examinations consist of 4 papers. One is the translation paper, and then there are law paper 1, law paper 2, law paper 3. So usually it is like this. Morning you have a paper, afternoon you have the second paper, next day, third, fourth. So 4 papers in 2 days. Alright, so that is the pattern of the main examination. Translation paper. Candidates are required to translate passages in English to Kannada and Kannada to English. The passages will be from depositions, judgments and documents. So reading of real case files. If you go to an advocate's office, you get assigned attached to an advocate's office, even in your college days. If you go there, reading those case files becomes very useful. Real case files, like case files which are there. So you are reading the pleadings in English, then there are depositions in Kannada, which is the same thing, or the same thing is stated there. So by reading these real case files, not only you get an idea about how cases are drafted, how litigation goes on, but also you pick up the code language, the words, the legal language that are used in day-to-day court, and you get familiar with those words, and translation part becomes easier. Unless I have dealt with the subject in detail, I will not repeat, but repetition helps you revise, and that is my only intention in repeating this point. Translation need not strictly be the verbatim of it, literal translation of it. Okay, it has to be that substance has to come from each sentence. That substance has to come. So that part we have to be clear. So the meaning should be same. That is important. So if you go for the literal translation, then it will become totally like Google Translation. My father's name is Halaba. ನನ್ನ ತಂದೆಯ ಹೆಸರು ಹಾಲಪ್ಪ. literal translation is not necessary. The substance has to be translated, the meaning has to come. Law paper 1 consists of questions of CBC, CRPC, CBC Code of Civil Procedure, CRPC Code of Criminal Procedure, which has now become BNSS, Bharatiya Nagarika Suraksha Samhita, IPC Indian Penal Code, which has now become Bharatiya Nyaya Samhita, and Evidence Act, which has now become Bharatiya Sakshya Adhikar. Principles of pleadings and Constitution of India. So here the law paper 1 has been divided into subjects covering these subjects. So questions on these subjects will be there compulsorily in law paper 1. So being thorough with these subjects is necessary for cracking law paper 1. When it comes to law paper 2 and 3, these are about writing of civil and criminal judgments mainly. Along with the civil judgments, you will have question on framing of issues. So there will be a set of pleading. What does the pleading mean? Pleading includes both plain and written statement. So they will give you plain and written statement as substance, and you will have to frame issues. Then you will have the entire deposition, pleadings, exhibits. Exhibits are the documents which are marked in the evidence. So then you have to write a judgment. You, for preparing as to know how to write a judgment, you have to read judgments of real courts. That will help you a lot. You will understand the pattern as to what is the format in which the judgment. There is no particular format given in any law as to how a judgment should be written. In stricto sensu, there is no such format. But as a matter of practice, a format has been adopted. As first we have a kind of a title, then we come to the facts which are pleaded by the plaintiff, then what is the defense of the defendant, then the issues, then what is the evidence led, then the reasons part, and finally the conclusion. This is a logical sequence. So you can understand the logical sequence when you read these real judgments of the courts. So when you are appearing for judicial exams for the post of a civil judge, it is better to read the judgments of a civil judge. Don't follow the format of say high court, because constitutional courts have a different set of format, and when you are appearing for the exam for the post of a civil judge, it is necessary for you to go through these judgments written by civil judges in the real courts, so that you understand the pattern, format, and the sequence, how it has to go about. Then reasoning. Reasoning also is very important. By reading these judgments, say, if you read about 20-30 judgments, then you will understand how the judge has given reasons to the conclusion to which he has arrived. So that will help you crack law paper 2. Similar is the case with law paper 3. It is about criminal judgment. So here along with in civil in law paper 2, you have to frame issues and write civil judgment. In law paper 3, you have to frame charge and write the criminal judgment. As to what is the substance of the accusation, that is the whole crux of a charge. You, Mr. So and so, it is alleged that on so and so night, at so and so time, at so and so place, you assaulted Mr. So and so and have committed an offence punishable under section 323 or 324 of the penal code. So that's how a charge is framed, depending upon the offence which is alleged. Issues, for example, in a suit for injunction, let us keep it simple and take an example of a suit for injunction. So in a suit for injunction, what are the pleadings that the plaintiff makes? He says that I am the owner of this particular land, I am in possession of this land from so many years, and now I am putting up a construction, and this person who is a stranger to the property and as well as me is coming and interfering with my possession. This is the substance of pleadings. This normally in a suit for injunction. Defendant may say issues would be whether the plaintiff proves that he is in possession and enjoyment of the sued property. Second issue would be whether the plaintiff proves that the defendant is causing interference to his lawful possession. Third issue would be whether the plaintiff is entitled for an injunction. Okay, so this kind of, when pleadings come, pleadings are given in law paper 2, you have to read them and narrow them down to these issues. Reading of Order 14 is very important. Thorough understanding of Order 14 to frame issues is very important. Similarly, the relevant provisions under CRPC relating to charge, thorough knowledge of those provisions is very important to frame charge. Okay, these are very important so that we narrow down the scope of our judgment. Here we come to know what is the issue involved in the case and what we have to decide. So, this understanding is necessary for cracking law paper 2 and 3. Option is given to you to answer these papers in either English or Kannada. Alright? But translation, you cannot say that and use this option. Okay, translation, if it is from Kannada to English, it has to be from Kannada to English. When it is from English to Kannada, it has to be from English to Kannada. Other papers, law paper 1 to 3, you have the option of answering these question papers either in English or Kannada. After you clear preliminary exams and main examinations, you will be called for an interview, which is normally conducted by 5 honorable judges of the High Court. So, this interview is called dialogue, and here the candidate's general knowledge, grasp of principles of law, and suitability for appointment as civil judge will be ascertained, will be tested. Here you have to be thorough with, again, you should revise preliminary exams, notes, updated during main exams, again update them before your interview. Keep every provisions should be on your computer. That's where we get our section 11 of CPC. Constructed and certificate. Anybody who answers will get it sorted. Explanation 4 of section 11 of CPC. So stay of suit, section 10. So execution of suit. So each provision should be on your fingertips. That will help you a lot during your interview. But when you are concentrating on these subjects, you should not ignore other subjects of law during your interview. During my interview, I was asked questions from the Contract Act, on bailment, on indemnity. I was asked questions on Partnership Act. I was asked questions from law of courts. I was asked questions about voluntary non-fitting delay. I was asked other exclusive cause of non-lawful action. Exclusive cause of non-lawful action. So on all these things, questions may come from any corners of this legal field during the interview. It may not be restricted to, and there may be confusing questions also. Who is the hostile witness? Okay, is it a concept of criminal law or civil law? Yeah, exactly, that is what I said. But can't you tell hostile and civil law? What does it mean? Is a hostile witness defined anywhere in the Evidence Act? Plaintiff in a civil suit brings somebody to support his case. He comes before the court and says totally hostile, he gives a hostile evidence. He is also a hostile witness. Then suddenly I just recollected, good sense prevailed, and I corrected my mistake. So all those things during the interview, main thing is confidence. In any interview, confidence is very important. Confidence is not there, of knowledge, and you have to be able to express it at the right time. Bonvita quiz contest, there used to be a Bonvita quiz contest in the olden days, and there was a tagline: if you know it at the right time, then you are the best. So interview is